All right, Bill Henshaw here again, Constitutional Kook Headquarters, and just some general thoughts from my listeners, and I appreciate all of you. And I just want to get across to you, what it is I do and why I do it, and that's important to know because when you get into their courts, quote unquote, and soon enough, by the way, they won't want to see you anywhere near any one of their courts, just like they don't welcome me in there if they can't beat me. And that's what you'll learn to do with getting my modestly priced constitutional defense document packets. Send me an email, u1incourt@gmail.com. And just a couple of them that I have, the bill of particulars uh, that would seem to apply only in a criminal setting, which is not true because every setting you're in and their courts are military tribunals. That's at least quasi criminal. And this beats them because they can't answer any of the questions. And the Sixth Amendment and the Ninth Amendment, in my view, we clearly have the right to know the nature and cause of the accusation, that's jurisdiction and venue of the trial court, the identity of the elements of the quote unquote crimes, and these days you'll learn that they're all federal commercial offenses, and most importantly, the identity of the injured party, and they don't have one. There isn't. And they have to have one because without that, we can't invoke our unopposed right to confrontation and cross-examination. And that's where it's going to get really interesting here, especially for like in a traffic court setting, for example. And this is typical of all of them across the board, is you get the dumbass law enforcement thug in there if they show up. In my cases, they have a tendency not to show up and the charges get dismissed. And if you listeners out there ever see a cop get charged with a willful failure to appear, especially in a traffic case, I love to hear it. That's what they do to us. And you might ask, where's the equal protection they're so big on here? But that said, this is how we get them because no injured party. And even if the cop shows up, it's hearsay testimony. He hasn't been properly trained to know what the law is and how to apply it. And a lot of that, by the way, you'll find most of the statutory schemes, if not all of them, are based on the non-existent 14th War Amendment. And the only citizens, or as I say, citizens in some of my paperwork it covers, are artificial corporate entities. And you probably aren't one. I don't know why they're not teaching these law enforcement thugs, to leave us alone. I mean, there's absolutely zero jurisdiction there at all. And especially with these statutory schemes that they allege you violate, like I just had a big win in a case where my friend was walking her dog in the park and got cited with some ludicrous BS federal violations that they couldn't even prosecute in a state court, even if they existed. And the problem with that is no injured party, and the cop giving testimony can perjure himself left and right. The U.S. Supreme Court has ruled the case called Briscoe versus LaHue. Don't have the site off the top of my head, but I think it's 461-309. Don't hold me to that. But it ruled basically that these law enforcement thugs have almost blanket immunity for any and all perjury committed on the witness stand. Now, these bastards, along with the local dumbass, has the burden of proof beyond a reasonable doubt. And they don't have one iota of relevant admissible evidence. This leads to questions leading up to your appearance in court, quote unquote, as to why claims like this were even permitted to be filed and what your local dumbass is doing there in order to get them filed. It makes no sense. At least on the surface, it doesn't, because they can't convict anybody of anything. What they do end up doing behind the scenes, and I'm not fully up to speed here, but they make a hell of a lot of money in those undefined dollars, based on some or other trust law and other BS, where they get a lot of money every day for just having cases active, often exercised against our social insecurity trust funds, a video for another day. But these are the kind of things that you learn and how to take care of it. And now I'm making a special effort for viewers out there, because what you want to do is absolutely demand your right to trial by jury. And it's not going to happen. This recent case you just had dismissed, they finally came to that conclusion. And on the Monday before the Friday hearing, for jury considerations and all, that's when all the charges were dismissed. because people, even if they have, you know, the uh, the statutes and have the violations, they don't have the courtrooms, quote unquote, anywhere in sight. Because for a trial by jury, even with Joe Sixpack, pro se litigant, we're there in proprietor persona. We do not appear pro se. They don't have time because, you get my materials and send me an email, youwinnincourt@gmail.com. At the moment, you get almost 600 jury instructions. I suspect by Easter time, it's going to be closer to 700. Now, what happens there is you demand a right to trial by jury, and among other things, they have to select a jury, and you're going to learn that there are no qualified jurors in the juror pools that they have. I mean, it's absolutely astounding, but so simple when you think about it, because all these jurors, quote unquote, have to sign a form declaring under penalty of perjury that they owe their non-existent birthright citizenship to the 14th Amendment, which doesn't exist. And they're not jurors, not only are they not peers of ours, they have irreconcilable conflicts of interest against us, whether they know it or not. So they can't select jurors. That process could easily take a day or two, or maybe a week or so with O.J. Simpson. And then you have jury instructions on both sides you have to go over to decide which ones are going to be allowed and which aren't. And I don't think the dumbass or the black robe bastard has any authority in that area. We have a right to get our theory of the case to a jury, a common law jury, which has the power to rule on the facts and the law. That's the ultimate check and balance we have. And that's what beats the state bar associations across the country. They can't control that. As we instruct the jury as to what the law is, and with my materials, by the way, you get a complimentary Zoom appearance from me in any contested hearing in your case. I have your backs here, people. You also get a lot of advice by TLC as much as time and circumstances permit, complimentary phone consultations. I mean, I have your backs. I want you to get up to speed, and you can do it a lot faster than I did. I didn't get all this for a long time either. When it finally hit me, the magnitude of the scam is, you hardly even know where to start. But that's what you'll learn here. And then you can teach your children and your posterity to do the same thing, and maybe keep them out of a lot of trouble from day one. Because when they know that you know, that's when they stand aside, because you'll learn they can't fine you any amount of undefined dollars, and they can't throw you in jail, especially if you're not represented by counsel. That's the U.S. Supreme Court saying that, not me. Augustine v. Hamlin, 407 U.S. 25, page 40. So it makes no sense even to go to a trial under those circumstances. That's the power that we have, and we're supposed to. All we have to do is learn how to exercise it. And I wish I had known 50 odd years ago in high school, but they didn't teach me a damn thing either. As they say, better late than never. And I'm here to help you and teach you and get you started. And we can do some amazing things. Because what you end up doing at first, setting an unopposed record in the trial court that we can come back with and burn their asses later. How good is this? It's the way it's supposed to be, for crying out loud. So that said, I don't want to run on too much here, but send me an email, youwinnincourt@gmail.com. Subscribe, like the videos, tell your friends, get the word out. Sooner we cut all this divide and conquer BS they've been doing for at least 150 years, the quicker we get them off our backs. Thank you.